Hello to everyone. Good morning, good afternoon, or good evening, depending on where you are joining us from today. I'm pleased to say that we have a truly global audience with us for this session, with representatives from countries all over the Arab world and even further afield, including Mexico, New Zealand, Korea, Serbia, Kazakhstan, Nigeria, Costa Rica, Canada, Brazil, and India. So truly a heartfelt welcome to our virtual venue from here in Dubai. 2020 has thrown intense attention onto the matter of technological development in legal systems, as most countries close their physical courts in response to the escalating health crisis. The reality of transitioning to a remote court system in the face of an emergency, however, showed how even the most digitally ready jurisdictions are not yet fully prepared for mass remote litigation. And as the demands on the legal system evolve over time, leaders in legal innovation will need to be strategic in their approach to prioritizing changes in practice. So for this webinar today, we actually wanted to break the mold of many of the legal innovation webinars that we have seen by providing anecdotal and practical points to hopefully shed some light for our attendees on how we should expect legal practice and the wider judicial system to evolve in the coming decades. Before we begin, I will give you a quick introduction to our esteemed panelists and their integral roles in driving court transformation in their respective countries. So I'm delighted that we are joined today by Paul Sanders, retired partner of Cravath, Swaine & Moore, New York, who has recently been appointed as a member of the Commission to Reimagine the Future of New York's Courts. This commission may be young because it was established just earlier this year by Chief Judge Janet Di Fiore, but its mandate is broad, covering not only short-term goals such as the resumption of physical trials after the ongoing health pandemic, but also how the court systems can take a view to working towards long-term innovation goals across technological and regulatory aspects. Paul brings valuable expertise from his time in private practice, as well as his contemporary insights into the process of transforming a court system that hosts, as you know, some of the most high-profile litigation in the world. Alongside Paul, it is our privilege to also have Ken Weitan with us, the Chief Transformation and Innovation Officer of the Singapore Supreme Court. Singapore is commonly cited as being one of the most digitally advanced court systems in the world and is one of the most efficient. So part of Singapore's modernization was facilitated by the establishment of Singapore's Courts of the Future Task Force in 2016. And it was mandated to come up with ways to improve access to justice and the efficiency also of the legal system through the introduction of technology. But Ken has been actually actively involved in innovating the court system since the 90s and understands both successful strategies and the common pitfalls that change initiatives can run into. We also have Francie Hansford, who is the director and the justice lead for PwC in the UK. Some of you may already be aware of the efforts that Her Majesty's Courts and Tribunals Service in the UK has undertaken since 2016 to reform its court system, investing £1 billion into modernizing and technologizing justice administration, a project in which PwC and Francie played a leading role. Francie will be sharing with us her insights on the change management considerations that are needed to sustain reform programs and the relevant lessons for countries that are just starting out on their transformation journey. And finally, someone who hardly needs an introduction, we also have our founder and chairman, Essam El-Tamimi, joining us as our fourth panelist. Essam is a venerable statesman in the UAE and in the region's legal sector, with more than 30 years practicing as both a litigator and an arbitrator. And in addition to leading the private practice, Essam also plays an active role in spurring the UAE's ambitious modernization efforts across many areas of law and legal practice, and brings a unique perspective as a key stakeholder in the UAE's future system. So as you have heard, our speakers have unparalleled expertise and in so many elements of court transformation. So I know we will be hard pressed to get through everything in the short amount of time available to us today. However, we also want to hear from our audience members. I will do my best to leave some time for a Q&A segment at the end. If you do have a question that you would like to be put to our panel, please feel free to submit it using the question box on Zoom. And of course, we will try our best to get through as many as possible. And I would also ask you, when you write your questions, please let us know where you are joining us from so that we can all vicariously travel the world together and escape the current lockdown measures and transit difficulties. So Paul, as I mentioned, you were recently appointed in June 2020 to the Commission to Reimagine the Future of New York's Courts. That's a very grand title to match an equally ambitious project, and efforts on that scale require enormous energy and motivation to mobilize. So can you tell us what are the main forces driving court transformation and what is the ultimate goal, please?
Good morning, good afternoon, good evening, all. Thank you, Ibtisam. Other than the pandemic, which I will put aside for the moment, the principal forces driving change in the court system in the United States, and in particular in New York State, are two. What we refer to as the access to justice gap and the delivery of legal services gap. That means, for example, that in New York State, every year, more than 2 million people, litigants, go to court without a lawyer. And more than 2 million people in New York State have legal problems that need to be solved by a lawyer, and they don't even realize that they have those problems, much less how to resolve them. So the question that we have been looking at, and people in the United States generally have been looking at for the last 10 years, have been how to increase access to justice and the delivery of legal services. It turns out that is not as easy as it sounds. People thought for the long time that the way to increase access to justice was to require lawyers to conduct pro bono services for free and to pay more money to the legal services organizations like the Legal Aid Society. It turned out, as the American Bar Association concluded about 10 years ago, that those were failed projects. Neither one of those actually worked to solve the access to justice problem. So what we are now looking at in New York and in many other states in the United States are ways in which to increase the efficiency of courts and to reduce the log and the backlog and to make courts more accessible to the customers, the litigants who are actually the customers of the courts, using such things as technology and better management and more efficient decision-making by courts. And even some states are now beginning to experiment with allowing non-lawyers to offer certain projects that's just beginning. We don't know how that's going to work, if at all, but those are the ways in which we are trying to address those two fundamental problems: access to justice and delivery of legal services.
Thank you very much, Paul. Franzi, following on from the issues in New York that Paul has just mentioned, you also encountered similar themes through your work with the judicial sector in the UK. So the top-level reform effort was centrally focused at making justice simpler to access and use and more efficient to run. But can you tell us what kinds of changes did this involve? And also, how did you assess what areas needed improvement under the project?
Yes, of course. And there are some strong parallels with what Paul just covered in terms of making access to justice easier. That was definitely the foundation and the very early aspiration behind the reform program. And as you mentioned, PwC was the delivery partner for the justice reform program in England and Wales between 2017 and 19. So that's mostly what I'll be talking about. And that involved HMCTS, which is Her Majesty's Courts and Tribunal Service, the administrative function behind criminal, civil, family, and tribunals, together with the judiciary, and that's really important, investing more than £1 billion in transforming the setting of justice. So their technology, the estates, the skills and the capabilities over 7 years. So the program is still ongoing, is currently projected to conclude in 2023. So whilst we've seen many results, and I talk about them later on, it's still very much work in progress. And to give you a bit of a sense of scale, just before I get into the changes, HMCT has a workforce of 17,000 FTEs, mostly in administrative roles, around 18,000 judiciary, about 19,000 magistrates, and it deals with about 4.4 million cases per annum. So it's a really large organization to that extent. And the program was really a wholesale change, really touching every aspect of the operating model of the entire organization, from criminal processes, civil, family, and tribunals. But they fall largely into 3 themes. So the first one was a focus on buildings, the physical estate, and the need for physical hearings. And because the system was still really paper-based, there was an over-reliance on physical hearings, and scarce resources, limited money was being sunk into a really crumbling estate with high maintenance costs. And that was one thing to address. Secondly, the focus was on eliminating the inefficient paper-based processes, which made it really hard to administer justice, but even harder to navigate the system, as Paul was touching on. So the objective there is very much to deliver a much more customer or user-focused service, but also to get better access to data. So to reduce a whole number of different IT platforms and create a much more integrated system. So many of you may have heard about the Common Platform Program, which is the integrated case management for criminal justice, running all the way from policing through to courts into prosecution. And then we had a scenario where courts were still solving issues that are potentially better dealt with elsewhere. And I know that's a topic in different jurisdictions in the world, in Australia as well. So one aspiration was to move around 800,000 magistrate cases out of the courts and online, and more than 1.5 million civil cases, which is now starting to happen. Okay. And the final area of focus was just an alignment between time and effort, where very simple processes took a long time, and that can be remedied with automation, reducing and modernizing the workforce.
Thank you so much, Franzi. Paul, I'll come back to you for a second. Actually, when we talk about this kind of problem in the judicial sector, we are really talking about systematic failings or inefficiencies that are not likely to be resolved by a single adjustment, but rather multiple changes in many areas. So what kind of solutions are you seeing implemented, technological or otherwise, and what are their limitations, please?
Well, one solution that we are looking at in the Commission to Reimagine the Future of New York's Courts, I'm embarrassed to say, is electronic filing of papers with courts. It turns out that in New York State, we have many, many, many different kinds of courts. We have at least 10 different courts that are able to conduct trials, for example. And it turns out that many of those courts do not allow electronic filing of papers and briefs. So one of the things that we're looking at is to try to figure out how to create a statewide methodology for electronic filing of papers. Other things that we're looking at, and the state of Utah out in the West is probably the prime mover in this regard, is something called a public access portal, which is a computer that members of the general public can access to obtain information about the court system, information about their cases, and even sample documents that could be used without the assistance of a lawyer to help these unrepresented litigants prepare the papers they need to file in court to move their case along. The state of Utah has what they call do, search, and self-help. Do would be using the portal to pay fines and things like that that the litigant needs to pay. Search would be searching the court calendars and other records to find out information about their case and other cases. And self-help would be getting minimal legal assistance through the computer to help them prosecute their case without the assistance of a lawyer. That's one thing that we're looking at. Another thing that we're looking at, this is driven primarily by the pandemic, is virtual proceedings. Our Supreme Court, which for decades refused to allow its proceedings to be televised, is now conducting all of its oral arguments virtually. There is no in-person oral argument in our Supreme Court. The same is true in many, many courts all across the United States. This is something brand new for us. The technology is new. Many judges and court systems don't know how to use the technology, but I must say that is here to stay. We are going to have virtual court proceedings forever, in my opinion.
Thank you, Paul. Ken, I mentioned at the beginning that Singapore has one of the fastest average rates of litigation in the world. So clearly you have had some measurable success in your technologization effort so far. And I mean, I recall that the World Economic Forum reports that in Singapore, it takes approximately 164 days on average to progress a dispute from filing and service to trial, judgment, and enforcement. So can you please shed some light and tell us what technologies are the Singaporean courts introducing and what solutions are on the horizon?
Well, I think it's very convenient that Paul just mentioned electronic filing. We found electronic filing to be a key linchpin in all our efforts. So we were very fortunate, being a much smaller jurisdiction than even New York, that in 1997, we actually required all civil matters to be done with electronic filing. So we have had many iterations of electronic filing systems. We're now into our second major system. And because we managed to move everybody to file electronically, it was much easier for us to pivot to remote video hearings when we needed to at the beginning of this year because of the pandemic. So electronic filing and remote hearings were a lot easier for us to achieve. We have a large slew of other projects which are currently underway. Access to justice also features very strongly. For example, we have just launched a motor accident simulator to provide litigants with information about the possible blame apportionment, depending on their motor accident configuration, where is the relative position of their vehicles when they were involved in a motor accident. We have also launched an authentic court order system so that litigants don't need to get certified orders of court anymore. They can obtain a electronically certified version from an official court repository whenever they need to get a copy of the court order. The third project I would mention is that in order to do a lot of things better than just replicating paper, we are re-engineering our court processes to shield citizens from the intricacies of the forms and the legal processes. And we are about to launch a new system for people to obtain simplified track divorces in a much easier manner, where it's a relatively uncomplicated scenario and the couple are largely in agreement. Finally, I would mention that to move into asynchronous hearings where the parties don't even need to be looking at the case at the exact same time. Yeah.
Excellent. Thank you very much, Ken. Essam, the UAE has been praised for being amongst the most innovative leaderships in the world, but we know from experience that there tends to be a lot of hype around innovation topics that can belie the reality. So please, from your perspective, how well is this accolade reflected in practice in the court system, but also what is the focus of the change in the judiciary and where has the investment been prioritized?
Thank you, Sam, and I want to welcome our speakers and our attendants. And it's a pleasure for me to be among yourself here today. UAE has invested heavily in the hardware and software late 90s, beginning 2000. However, I don't think they imagined they had to use them within 2 weeks the way it was used following the COVID-19. UAE for the last, I would say, 5 to 8 years tried to merge into electronic documents, filing. They try to use the IT with regard to reporting on hearing, filing application to the judge online. And for the last 2 years, prior to COVID-19, they were actually pushing toward it. However, the system was a mix, I would say, a 60% electronic, 40% was of the old-fashioned manual documentation, filing, bundle document. And there were on a certain occasion, even if you go and file electronically, you need to go and deposit the hardware. However, because they had the infrastructure in and the investments were made into the system majorly, they had to do a very small tweaking into the COVID-19 process. Within 2 weeks, everything has changed virtually. No court hearings anymore at all courts, Supreme Court, Appeal Court, Court of First Instance. It's happened virtually. Judges send you the links, and court clerks works with you on a daily basis. All the filing has been done electronically. However, is this enough? No, I think that was dictated and forced upon us by COVID-19. It's working for lawyers and user perfectly. And I think for our law firms, for example, and our practitioners and our clients, it's working perfectly in terms of filing, responding with the courts, making an application, getting the response from the judge, hearing, judgment, and so on. However, there is still a little bit of fear from the electronic system when it comes to using it and utilizing it to the maximum, whether it's because there's a fear of security issues, whether the fears of basically hacking, whether so they have not let this system go fully to able to service the entire court proceedings. I agree with Paul that this system is here to stay, and the interesting things about IT and use of the IT, it's get obsolete and old-fashioned very quick. So I'm sure that now that Dubai and the UAE get a flavor of this system, lawyers, users, and the courts start interacting electronically and finding it efficient, working perfectly. And I am very optimistic that now that we have the infrastructure and we got the experience in tasting the flavor of working this, the next jump will be a big jump in the UAE, and I think they're already preparing for it.
Thank you very much, Hassam. Paul, if you allow me to ask you an additional question here. Clearly, we cannot operate on the assumption that technology is a turnkey solution to all of the issues that are associated with court systems, based on what we have heard. So in New York, is the prevailing view that technologization is an enabler or a barrier when it comes to resolving access to justice issues? I think you're on mute, Paul.
That's a very good question, and the answer depends on the perspective from which you are answering the question. If you are a typical unrepresented litigant, a poor person without access to the internet, for example, 30% of people over 65 in New York State do not have access to the internet. So if you are relying on technology to help you move your case through the court system, you are stuck in what we refer to as the digital divide. You don't have access to the technology that you need to access the court system's technology. That said, if we can figure out a way to solve or ameliorate the digital divide, then the use of technology should be an enabler rather than a barrier to more efficient court systems. It improves access to the courts, it improves management within the court system of cases, and it ought to improve decision making. And I'll have a little bit more to say about that later on, about how technology could improve decision making within the courts. But on balance, I think it should be an enabler rather than a barrier.
Thank you so much, Paul. Ken, I just want to circle back to you now that we have heard of some instances where we need to look beyond the technology in order to modernize. So is the efficiency in Singapore system that we mentioned earlier purely the result of technological innovation, or are there other elements that you have introduced? And really, have you found instances where technology has not been an appropriate addition to the legal proceedings, for example? The reason why I mention this is because I believe that recently, I mean, at least as a result of the pandemic in France, they have extended actually the video conference capabilities for criminal matters without the necessity to having the approval from the parties involved. And this by itself has sparked a lot of controversy. So can you give us your insight and input from Singapore's perspective, please? You're on mute.
I'll be very happy to speak to both of those aspects. And I would say, similar to what Paul has also mentioned, that while technology is important, the overall transformation is more important. And that is why when the Chief Justice established a new unit to lead innovation, it was called the Office of Transformation and Innovation and not the Office of Technology and Innovation. The purpose of this is to signal that it is not simply a question of technology. As for what are the success factors that has made Singapore able to do what it has managed to do so far, I think in order to achieve the clearing rates that we see, we track every case. And we put in place active case management to ensure that every case moves along at a reasonable pace. And this requires tremendous effort. It is aided by the IT systems, the dashboarding, the information, the reports you can get, but it requires sheer investment in effort and in time in order to actively manage cases from cradle to grave. Now, as for France's experience, I cannot speak to the specifics of what was done or not done in France, but when we grappled with the question of whether to allow remote proceedings, whether it needed the consent of all parties, what we were very clear was that it needed to ultimately be in the interest of justice. And the courts had to make a positive assessment that having this proceeding proceed by remote video technology would be in the interest of justice. So if there were cogent arguments that any party could bring out that for specific concerns in a specific case, that a particular witness has shown a propensity to perjury, to being coached, for example, those could be factors that would lead to a court not allowing remote testimony. But we were very clear that everything that had to be done has to be in the interest of justice.
Thank you so much, Franzi. I want to come to you now so that we can zoom out a little to look at the process of implementing change. And because talking about transformation conceptually is all well and good, but when we come to put these ideas into practice, we can run into obstacles fairly quickly. So what challenges, can you tell us what challenges did you encounter in the reform project in trying to reach your objectives? And also what progress has been achieved to date, please?
Yes, sure. So if you don't mind, I start with the progress and then come on to the challenges, because it has been considerable, of course, despite the many challenges. And if you imagine a 7-year transformation with 55 projects across. But in terms of progress first, and these are largely taken towards the end of 2019, so just before COVID hit, we'd seen some real progress. So for example, in the criminal jurisdiction, HMCTS was now in a place where, for example, transport for London cases could be dealt with via the digital case management system, so no longer in court. People could now enter a plea online for the traffic offences nationally. And of course, again, that really created some capacity in courtrooms. Magistrates could use now an online rota system that could nationally match magistrates to court sittings quite effectively. Legal advisors could record case outcomes instantaneously using digital markup. And I think most importantly on the crime side, the major program around the common platform, which I mentioned earlier, which is the integrated case management system, is starting to pilot actually the first real criminal cases in the Crown Courts. And hopefully is doing more of that later on this year. And on the civil and family and tribunal jurisdictions, we have now seen a lot of the services becoming available online. So for example, civil money claims, the time to settle has halved as a result of the digitization, and user satisfaction, 9 out of 10 were really satisfied with it at the end of last year. The same is true for probate. So there's now a probate online service where people can register online, and 9 out of 10 were satisfied. If you've got an uncontested divorce, controversial, but yes, there's been an uptake of 50% of that registering digitally, and 80% said they're satisfied. And in tribunal cases, if you want to track your appeal online, you can now do so online using a case rather than having to call in or going into a tribunal building. So some real significant kind of step changes in terms of customer experience, but also creating capacity for the much more serious and complex cases. And there have been some remarkable successes in the enabling infrastructure. So now all courts and tribunal buildings have Wi-Fi, thankfully, given what was to come in terms of COVID. But we also helped HMCTS set up a number of national courts and tribunal service centers. So these are in essence service centers where a member of the public can seek information about the status of their case. Often they can self-service, but otherwise they're basically being directed to a well-informed and well-trained individual who can help them out with that. And last but not least, and this is an important element, HMCTS have managed to close down some of the underused and inappropriate court buildings, and thereby releasing investment in millions that they can then invest in the improvements in the system.
Thank you so much, Franzi, for this. Essam, you have been at the leading edge of court sector reform in the UAE and have seen both sides of the coin, helping to mobilize and shape the direction of change and simultaneously experiencing the fruits of these efforts through your practice. So have you seen similar human and legal deficiencies in the UAE in modernizing in the courts?
If I could have imagined in 1991 and 92, I could have a wonderful system that I could communicate with the court electronically and hear my cases in court electronically, I would have basically thought I basically live on a moon. So what the environment we're living today, if I compare it to what we had in the beginning of 90s, this has been perfect. However, is it perfect for today's time? The answer is no. There is a huge room to improvement. And you touched about the human part of it, which is the most crucial, because that's this system, the IT and technology and innovation, which Ken talked about, is designed to service people and designed to provide the judicial service of the community. So it has no limitation. The technology is the vehicle of that services, and it is available to you to the maximum. You can utilize it in the maximum way you want, and you can throw everything in the court system today. However, unfortunately, not only in the UAE today, most judicial system is utilizing it to some extent, not to the maximum, either because of the fear of technology, fear of security, or the people who's behind the desk are not trained enough to be able to drive this. And that's why you distinguish, in my opinion, from one country to another, is because of the team. Yes, UAE has, and Dubai and Abu Dhabi has put a lot of effort in training the people through the use of technology, and they have managed to get us to where we are today. But that's not all what I think users are hoping for. I think there is a huge room to grow, and there is no growth without this, without changing mentality, culture, and the training of the human behind it. And again, it's also generation. And I think very few people could jump that generation gap. For example, the iPhone, for one person using the email for iPhone will have been the maximum imagination of their use. For another person, no, that's basically scratch on the surface. The iPhone is utilized to run their entire office. And that's what we need to get to the mentality from the person who thinks having a computer and a keyboard and sending documents for filing is the perfect judicial system, to a person where basically in our speaker example, you can actually get a legal assistant through some portal and through computer system, whether it's the traffic cases in the example we're giving, or whether those family cases, or as simple as providing some user who don't have a lawyers of certain access to documentation. So the limit is the sky, and then that comes the people behind it, who either basically get hold to their own old tradition and grow very slowly, or they basically innovate. And again, I believe in the age gap, and some of the human resources needs to bring in the younger generation to be able to build this into the system.
Thank you very much, Essam. I mean, despite these challenges, we know that the UAE is still better poised to pursue strategic plans due to its relatively agile governance and appetite for transformation. But when we look at the makeup and the culture of other countries, I expect the disparities would bring corresponding differences in the types of challenges experienced in the course of change. So Paul, if I may ask you, what kinds of barriers can prevent the level of prevalent reform that is needed to overhaul the court systems?
There are several barriers. The principal barrier that I see is the failure to communicate with each other. As I said before, we have a very complex court system in New York State, probably the most complex in the United States, because it's very old and has been added on incrementally without ever doing a comprehensive court structural reform, which our chief judge is now trying to accomplish. But because of that, the judges really don't communicate with each other. There are not good systems of communication back and forth one to the other. Some judges, especially the younger judges, are far more technologically savvy than other judges, who are basically stuck in the past and who say, this is the way we've always done it, this is the way we're going to do it, we're not going to change. I was in court once on a technology case, and the judge made a comment that I really didn't understand, using a phrase I didn't understand, and the judge looked down to me and she said, Mr. Saunders, ask your granddaughter. Because she knew that my granddaughter would have understood what she was talking about, but I didn't. So lack of communication is a very important part. The second part is figuring out ways to modernize the system to make it more accessible. In New York State, for example, we have what is called the Civil Rules of Civil Procedure. I'm embarrassed to say it's a book that weighs 3 pounds. I don't think there's a human being on this earth who has ever read that entire book. Those are the rules that apply when you bring a case in a New York State court. They need to be changed. It will be decades, if ever, before there will be a comprehensive overhaul of those rules to make the system mesh with the technology that makes more efficient practice possible.
Thank you very much, Paul. Ken, I mean, we have heard the human element is clearly an issue, but it is one that can be accounted for and mitigated, of course. So in your experience, what attention is the process?
Absolutely. Change management by of the users is crucial to the success in many of our efforts, probably all of them. And back to this question about the digital divide, it's not something that just affects litigants and unrepresented individuals. It's something that affects lawyers as well. There could be lawyers on the wrong side of the digital divide as well. So we try very hard to engage early with all stakeholders. So for example, at the beginning of this year, when it was quite clear that we would have to head towards remote hearings using video technology, we made sure that we spoke with the technologists, but more importantly, we engaged with members of the Law Society, we engaged with the Public Prosecutor's Office, and we also thought that it was useful for us to discuss things with the policymakers. And so we spoke with the Ministry of Law, And when emergency legislation was passed in order to facilitate COVID measures, we were able to ask for emergency measures to make it clear that the courts had power to do all the remote hearings and all the extraordinary changes that we have put in place in a very short amount of time. So change management is absolutely crucial, and I cannot emphasize that enough.
Thank you very much, Ken. Sam, I come back to you now. These are clearly integral parts of the change process that have a monumental impact on its ultimate success. So would you say that technologization agendas will inevitably fail if the legal and knowledge frameworks are not considered in tandem?
Of course, Sam, there's two elements of this. One, of course, a pure legal and procedural issues where the technology process in court need to be backed up by a substantive law to back the process, whether it's relating to the data and the process and the due process. And I sit as an arbitrator, of course. And one of the things I think I'm going to go slightly above the subject, but court is being challenged today with arbitration. So unless the courts modernize themselves, I think arbitration is taking away a lot from the courts, and they will take a lot of it. But coming to the legalization, of course, the law need to be there to give the parties the confidence in the process, as well as the protection they need, as well as the framework in which things could go into the process where you could trust a machine in deciding on your traffic case or otherwise, or paying the fine, for example, or getting the receipt. These are legal issues need to be accepted, that the basically receipt of the documents can be accepted. But also beyond that, Ibtisam, and it's part of the legal issues and legalization, the education in universities. And unfortunately, the court system, because of the recent changes, has took a huge jump into changes. But a lot of universities around the world still very classic in their education, in their teaching of the law and teaching of the process. And I think that's need to be taught differently today to bring a new generation into. So it is a legal issue that need to have the right platform, legalistic, but also need to prepare the new human, which today, as Paul says, the young generation mentally ready to work electronically. Just when you teach them through law school, you need to get them into that channeling to be able, when they come out of law school, the only thing they know is working electronically with the court.
Thank you very much, Hassam. Paul, I will come to you again so that we can focus on some of the lessons learned through previous efforts. So technologization is not a simultaneous process across the world, and some courts have raced ahead with the investment, whilst, as we know, others are only just beginning to consider their modernization strategies. So what can courts that are at an early stage or earlier stage focus on if technology does not necessarily provide an appropriate solution to their problem?
Well, I mentioned something earlier in the program that I hesitate to mention, but it really might be a solution to solving the access to justice problem for the future if technology cannot carry the weight. And that is, and we are seeing some states in the United States experiment with this, and I know that the UK in the Legal Services Act of 2007 has also experimented with this, and that is allowing non-lawyers to provide certain limited types of legal services and advice, and even to appear in courts in certain very limited proceedings as a way of improving access to justice. I should say that those projects in the United States are at the very, very early stages. We really don't know how they're going to work and whether they are going to be successful or not. We've seen the experiment in the UK for England and Wales that limited the practice of law to 8 particular categories that could only be performed by barristers and solicitors. And so it remains to be seen how successful that experiment is going to be, but that is something that we in the United States are looking at.
Thank you, Paul. Franzi, for countries that are just starting their legal transformation processes, can you just, can you give us your perspective on the critical success factors, please?
Yes, of course. And I would say they link, at least in part, to the challenges you wanted to hear about earlier. So for me, there are three. The first one, which has been talked about already by Paul and Ken as well, is the absolute importance of stakeholder buy-in and in particular judicial buy-in. So in the UK, that was solved through ongoing extensive stakeholder engagement, but also joint governance, whereby the judiciary and the courts administration and the treasury are really represented at the top table. Interestingly, in the early stages of reform, the program was asked to slow down because it was felt that just not quite enough engagement with the public, with the customers, with the affected party was possible. So there's a sort of balancing act between speed and the level of engagement. And anyone who sets out on a large scale transformation, I would say, treat that engagement piece as absolutely essential and give it kind of a sort of due profile. Secondly, I would say that it's really important not to keep the eye off the business as usual operations that are running in the background. It's quite easy to get distracted by the new shiny technology and the new changes, but often they take years. And in the meantime, you still need to deliver your business as usual operations. And you need to really consider the ramp down of your legacy systems, your IT systems, because only when that happens, when you really release some of the benefits. And therefore make sure that there's at least one lens on BAU and that kind of transition element. And then thirdly, I would say, and again, this leads to Paul's point and Ken's point around technology the reform shouldn't be technology led. In the UK, it's often sometimes been talked as digitization of the courts. That's not how it should be positioned. It's modernization of the justice system, of which technology is one element. And it should be business-led and customer-led, not technology-led. And within that is a really interesting balance and decision to be struck to what extent you customize a digital solution. So should it be, as Paul was mentioned, go really far in terms of assisted digital for those who can't really access the mainstream digital solutions, or to what extent do you want to go with an off-the-shelf solution, which may be cheaper and faster, but maybe not as customized?
Excellent. Thank you so much. Hessam, these are clearly transposable principles to transformation in other circumstances. But your leadership, Hessam, actively involves not only transformation in the court system, but also in the private practice for law firms. So do you see the same drive for digitalization and innovation in legal services, or are these dynamics slightly different? And do you think, or do you believe that the clients and the GCs will ultimately expect alignment between the court systems and the private law firms?
Generally, I'm optimistic of the private sector and the general counsel. However, it's actually very unusual what happens in the UAE. The governments took an initiative maybe 15, 20 years ago to bring the IT and digital systems into their governments. So there were a lot of investments in hardware, software, and was used marginally. When the COVID-19 happens, they were ready to utilize this big investments that they had made over the year. So the funny about it, that's actually the courts were slightly ahead of the lawyers in the UAE. So lawyers were not basically as ready to utilize the transformation into digital system, unlike many other countries. Surprising to me that within 2 weeks the courts were ready, and they were ready to hear cases and hear witnesses and present documentation and deliver judgments. And it's, to my surprise, is working well. And I like the statement that basically modernization of the legal system, which Franzi has mentioned, because there is a huge room to utilize this technology to do further. However, the private sector is catching up very fast, because, as you know, private sectors they spend their money where they're and they follow the client's interests. And if the client's interest is going into getting their cases done quickly through digital and having to use the courts efficiently, there's a huge investment has been made through the private sector, including my firms and most of the major firms, and the small firms are follow. And I'm very optimistic, at least about the UAE's economy. And I think that we will be in a different stage in a year or two with all this. However, I'm not sure that beside the digital investments, there has been the training and the talent that needed to help implementation. So that's, in my opinion, something that needs an investment in training, education. I wrote an interesting article, one of the British firms today, that they're basically going to be creating an academy to train their young lawyers and their teams to be able to utilize the new digital world. That's things need to be coming into the private sector and the in-house counsel, because again, cost is extremely important for clients now. And I think in-house counsels and lawyers could save a huge cost on clients by use of technology, and if they embrace into the class more and more every day.
Thank you so
So
much.
I just wanted to add something to that. One thing that I think that the future is going to hold for all of us in the legal services business, that I, for one, really don't fully understand or understand much at all, but I think it's the way of the future, and that is artificial intelligence. I've been told that one of the circuits Court of Appeals here in the United States is going to hold its next circuit-wide conference on the subject of artificial intelligence. I think that is something that is almost with us, and we need to understand how that can be used in the legal services profession and industry and systems. The only example I can come up with, and it's probably a very weak example, is patent infringement. My sense is that the use of artificial intelligence will fundamentally change patent infringement litigation. And there may be hundreds of other ways in which it can be used, but I think it's something that we need to keep very much in focus for the near-term future.
Thank you very much, Paul. One final topic I want to bring into the discussion today, and which I think we cannot ignore, is the impact actually that the last 12 months and the onset of the coronavirus has had on how we understand the immediate priorities for the court system. So Ken, how did the health pandemic force Singapore to pivot in its vision for the future?
Thanks. I think that there was an epiphany when lawyers, judges, and prosecutors realized that the use of remote video hearings would reduce the risk to them, both in commuting as well as being in court with a whole bunch of other people especially early on in this pandemic, when the disease was such an unknown factor and we didn't know how the mortality would be. So it really prodded lawyers to be more open to accept change. Right? And some law firms did not use to issue notebook computers to their staff and lawyers. And some of them had to actually cart desktop computers and monitors home. And for better or for worse, the circuit breaker, as we called our partial lockdown in Singapore, the circuit breaker period that we had made everybody sit up and realize that there is a real need to embrace change. And what happened was the lawyers that had digital workflows could better pivot to working from home because their case files were electronic, right? Even if they're locked up at home, they could access their case documents. They could act on their advice that was required of them. They were used to communicating via email. Those that had paper-based workflows found it much harder. So this has really opened the door for the various agencies in Singapore to evangelize the need for law firms to adopt technology in an even bigger manner. And we're seeing possibly a huge growth in practice management systems so that law firms can put a lot of their billing, their client management, their case files into electronic systems. So the pandemic has been a great benefit in that sense. Yeah.
Excellent, thank you. Franzi, did you see a transition in the plans and objectives as a result of the health pandemic? I mean, and what impact did this have on the timeline and on the dynamics of implementation?
It's very similar to what was Ken was talking about just now. I mean, we did see an impact, so certain aspects of the change, especially the technology change, were significantly accelerated. And I think the primary example here is the cloud video platform that was just mentioned. Very similar here, over 65,000 hearings kind of happened now during COVID times using the cloud video platform, which really enabled the judiciary to manage and conduct cases with that sort of secure video conference facility. And had it not been for COVID, so I guess this is an element of silver lining, the plans were there, but they would have taken much longer. Now, of course, because load of resources needed to be diverted to make that happen at speed, other elements of reform needed to take a backseat. So some accelerated, some slowed down. However, I have to say, if COVID, I think, and the requirements it sort of, or the challenges it brought, did nothing other than confirm the reform agenda. Those elements of the criminal justice system, which had already been digitized by that point in time, fared a lot better, were a lot more resilient than those that hadn't been. So I would say it reinforced the case for change, and it reinforced the business case, and it will continue going forward.
Excellent. Thank you very much, Franzi. Essam, not that we are trying to look for silver lining in what has obviously been a very difficult and often traumatizing time for many people, but would you say that the health pandemic has had a positive or a negative impact on the ability of the courts to mobilize?
It definitely has accelerated the process, and this is already, and I fully agree with what's already had been said on this subject. It's definitely, before COVID, law firms and courts were investing in IT, use of IT and communicating with the client. They probably were thinking of an app, and they were studying artificial intelligence to see if it's basically can be incorporated in their business. Today, it's because of COVID, things got accelerated, and it has not been limited to that. Too many things basically has been brought into the subject. Number one, things were accelerated. We done it, it's working perfectly, and it's simple and can actually be perfected even more. And not only that, we discovered that the issues which we were talking to clients about saving them costs, money, getting them to work very closely with their matters and costs, accessibility to their files, is become much easier and possible to do online. So besides the issue of technology, many other components has actually come into this because of COVID. And I look at it in my practice, it's a good wake-up call to start looking at things beyond our original lens. And we have widened our lens much bigger in trying to not only dealing with necessity issues, but beyond that to be our first full service based on innovation and technology. And that's probably where we're heading at now.
Thank you very much, Essam. We, as you can see, I mean, we are tight on time as predicted, but we have had so many questions submitted throughout the session that I want to bring up a few of these questions before we finish and before we conclude with all of you. So I'll start with Hannah from Singapore. Thank you, Hannah, for your question. And that is the following. Given the pace of technological development, how can courts stay abreast of change, and how do in favor of a new one? I mean, Franzi, you have partially addressed this topic, but if you would like, please to comment on this. I mean, any of you, Ken, Franzi, Essam, or Paul, let me know.
So I think there's two parts of the question, wasn't there? How can courts stay abreast of technological advances? And then secondly, when do you know when to kind of retire? I would say answer the first part of the questions. I mean, platforms like the one you've just created today is really an ideal forum to exchange learning across the world, because we can already see the challenges are so similar, and we haven't even got Australia, Canada, some of the other jurisdictions here. So I think participating in some of this really helps. Secondly, I would say, I know a lot of technology firms out there, be it Microsoft or Salesforce or smaller like e-journals, everyone is very happy to share, very happy to showcase. So I think there is a sort of engagement between law firms, technology firms, public sector organizations, which all come to the debate to share a common problem, I would say. And I might leave it to someone else to answer the second part of the question.
Ken, would you like to comment?
Well, I typed in some thoughts on this question in the chat, but I'd just like to say that we just need to be very careful about proprietary systems. Things that are very tied into a specific vendor, I find those to be a little bit worrisome because they do tend to lead to vendor lock-in. And I do think that if you plan things properly and you isolate the data that you're storing, your data can be more or less immortal. Even if you change the front end, even if you change the systems that are used to access and to present that data to users, the underlying databases, a lot of that is fairly unchanging even over decades. But the front end, the interfaces that we design, whether you access it through a computer, an iPad, a mobile phone, those things can change without really affecting your back end. So we make a sharp distinction between the back end pieces and the front end pieces.
Okay, thank you very much for this. We have a question from Paulo from Brazil asking, I mean, when we talk about the future of technology in the courts, we cannot ignore other potential changes that are looming over the private sector, which is the other side of the coin in legal practice, and is under equal pressure to innovate services. So we hear so much about the future of legal technology designed to replace humans with computer processes. I mean, as we all know, we don't have time, unfortunately, to dive all the way into this topic, but can we at least, can I ask you please to at least red flag the areas that are more amenable to robotics? And can we also distinguish potentially between high-tech cases and those that require the human touch? If you would like to, who would like to?
I will take a crack at that. There's a process that some people have referred to in the United States called triage for legal cases, the same way triage is used in medical emergency rooms. That is, there's a way of having courts decide very early on which cases need the most intense scrutiny by judges, and which cases can be decided very routinely by maybe court clerks, for example, rather than judges. And that's a decision that, at least the proposal is, to be made at the outset. As soon as cases are filed, they go through a triage process so that the most significant, complex, difficult, and important cases get the most attention from the courts, and the simpler cases are resolved more easily and simply. That's one possible process.
Thank you, Paul. I'll move to the next question. Omar Mabid, do you think forming digital legal platforms for so-called online digital lawyers to provide selected legal services is needed and would be successful in the future? Who would like to respond?
I actually think it will happen, and I'm certain it will happen. Maybe it's not through the entire legal services, but those services will be available. And I'm actually won't be surprised in 10 years or 15 years, lawyers will have to partner or utilize these services when it comes to their advice. So these are powerful IT engines will be available and can be utilized for advice, maybe to the courts, maybe to some lawyers, and we partner with them to provide advice to clients. So I'm actually a believer that the changes has happened with the availability of, like Paul says, artificial intelligence, and the storage of so much data in certain computers, and with an innovative people who could program them in such a way, will be of a huge use and reliability to lawyers and legal practitioners.
Thank you very much, Assam. To conclude this very interesting discussion, I wondered if you could all spend 30 seconds to 1 minute just giving us your thoughts on what you think actually the courts in your respective jurisdictions will look like in 15, 20 years. Paul, if you allow me, I will come to you first.
There may not be any courthouses anymore. We may be entirely online. I say that somewhat facetiously, but I think we are moving in that direction. As Essam just mentioned, the online provision of legal services, legal advice, things like legal Zoom and so forth are fundamentally changing not only the practice of law, but the way in which courts are attempting to resolve disputes between and among litigants. They don't need to be in person, except possibly for criminal cases where we in the United States have criminal juries that must meet physically together. But with that possible exception, I think it's entirely possible that a vast majority of the future's legal services, judicial decisions and judicial services will be online, and we won't need courthouses anymore. They can become museums.
Thank you, Paul. Ken, how will it be in Singapore, please?
My crystal ball, unfortunately, is not very good, except that I would throw my hat in Paul's direction and agree with him. And that's a view that Richard Susskind, who we all know to be a real visionary where legal technology is concerned, the courts will increasingly be a service and not a place. And I think that for certain categories of cases, you might have a distinction between the high touch versus the high tech cases. So the high touch cases may be the ones which require a lot of management because there may be a lot of emotion. So if you're dealing with a messy divorce or a child custody matter where it needs a lot of management, a lot of counseling, maybe a lot of mediation, perhaps, that would be a high touch. But a lot of cases could be dealt with in a high-tech manner.
Excellent. Franzi, based on all the experience that you have had, can you tell us how do you see things progressing and how do you see the courts in the UK where you are based?
I would say in a very similar vein to what we've just heard. I believe that the channel in which the service is provided will go increasingly online, but the principles behind it of judicial independence, prosecutorial independence will hold. One thing that got me thinking, and it applies less to the UK, but some experiences I've had in Australia, and it goes to Ken's point around a sort of high touch requirement, is there are certain settings where the face-to-face really may still make a difference. And I'm thinking about, let's say, Aboriginal communities in Australia who have quite a different context of a setting. And now they've been trying circle courts where they're going out in the Aboriginal community and actually administering justice with elders. And that resonates and has shown some really promising results. So I do think there are elements where not everything is going to be online in 15 years, but who knows?
And Isam, finally, can you tell us how do you think it will be in the UAE?
Before I go, I want to really thank our panelists for a wonderful discussion and our attendees, and I thank you, Ibtisam, for such an excellent moderation. I'm actually a big believer in changes, and I actually think I agree with Paul. We probably won't see the court exception in very limited circumstances. People who's in business want to resolve their commercial disputes in basically seek the resolution of a computer in the future or artificial intelligence. The only challenge, as I think Paul touched upon it in the beginning here, is money and funds. you will find certain countries will not have that accessibility because their lack of funding and trying to invest in the infrastructure. And that's, in my opinion, the challenge. Again, a second challenge, and that's why I think it's going to take maybe 10 to 15 years and maybe 20, our education system. It's also need to change. But I fully agree that between the arbitration today and between the digitalization of the courts, you will see less of people traveling from one country to another country to sit in a court to give a statement or be a witness. That's unnecessary. It's a waste of time. You don't have to basically send trolleys of files through the roads and crossing the roads and into the courts. That's not needed. With a small one buttons, you can basically transform so many documents, and some of it could be sorted out electronically, and that will happen. So the changes is happening, and I think the norm will be, in my opinion, digital. The exception will be to have a physical hearings, subject to the two caveats I just mentioned.
Thank you so much, and thank you, everyone. Unfortunately, we are out of time, but I'm sure that our audience members will agree with me when I say that your input today has been incredibly insightful, and I thank you for that. And it's readily applicable to the future transformation efforts in all of our countries. It has been a pleasure speaking with you all, and I wish you all the best with your respective endeavors. Thank you also to all of our attendees for joining us from around the globe and with the time zones that are completely different from one part to another. And to those of you that contributed your questions and comments, of course, I would say, please feel free to get in touch with us if you have any questions or comments on today's session. Stay safe, and we wish everyone the very best. Goodbye. Thank you so much.
Thank you.
Thank you.
Thank you.
Thank you.
Pleasure.
Thank you very much.
Thanks.